Do I hand over to you now?
Yes. So I'm going to touch upon the employment status test, which Mark's already mentioned as being quite a difficult thing to ascertain employment status. It's the same test under employment law that HMRC will apply in terms of ascertaining someone's employment status. So they will look at some of the case law from the employment law arena, and they will use those cases to try and ascertain someone's employment status. So I'm just going to touch briefly on, under employment law, there are three categories of an individual who will provide services or in the job market. So we have employee at the top, worker in the middle, which is the more grey area, and then we've got some self-employed at the bottom. And they're relevant for employment law purposes in terms of what employment rights they have. So an employee, as you might be aware, has unfair dismissal rights, rights to a statutory redundancy payment, those kind of things. Worker has slightly different rights under employment law status, discrimination, unlawful deduction from wages protection, paid annual leave. So that's the difference that we look at as employment lawyers. That's the murky world we tend to sort of try and ascertain between those two bits there. But if you're neither of those two, under employment law purposes, you're self-employed. Okay? But for HMRC purposes, they only have two categories. So they're only interested in either employee or self-employed. However, the case law will be from an employment law arena, and that will cover employee, worker and self-employed status. So if you're ever looking at case law, I don't know if you will ever be that interested in picking up an employment law case about employment law status, but you'll see those terms used. So the main point really is to understand that what will define somebody's status is the contractual relationship between that person and the person they're doing the work for, basically. And that, as we're going to find out, can be a little bit muddied. So as you can see, the first bullet point there is it can be clear as mud, and it is a difficult thing to establish. Whilst the same cases are used from an employment law perspective, they can be applied differently as well. So the main point to remember is that's in red, is that this isn't about proving self-employment, but disproving disguised employment. So that's what HMRC are looking at. They're looking at that relationship between the individual and what they're doing on a day-to-day basis, the reality of the actual situation, and what they're doing is looking to see whether this person is a disguised employee. So, as I've mentioned, it's the same employment status test. We look at guidance from case law with this. We look at the facts of each case and we apply and retain that assessment of what they're doing. So the way I look at it is it's almost like you've got an arrow in the middle, and some factors will start to point you more towards someone that's an employee. Other factors will start to point more towards self-employment, and it's a very difficult determination, and you are looking at the whole spectrum of what you've got in front of you. You're looking not only at the contract, you're looking at what that person does on a day-to-day basis, and that can be difficult to ascertain if you're not the person who's the line manager looking at what they're doing, for example. Who you know, what is that person doing on a day-to-day basis? So that's why you have to employ a good employment status test to try and work out which way is that arrow going. Are we looking towards employee, or are we moving towards self-employment? So we've got some guidance from the government, which I'm going to go through each one just to explain to you how this kind of works and how we look at whether a particular factor indicates more towards employment status or more towards someone that's self-employed. So the first bullet point you'll see is talks about the fact that they're required to work regularly unless they're on leave. And already you can see, well, someone can be employed but be on a fixed term contract, for example. Someone can be working like lots of different 3-month contracts. That person could be an employee. However, that person could also be self-employed. Those could be separate assignments on which they're engaged. So already that kind of guidance is something that could move that arrow one way or the other. Of course, if they're on sick leave or maternity leave or holiday, then that is potentially, and who's paying for that, is potentially an indicator of employment status. So the next one talks about they're required to do a minimum number of hours and expect to be paid for that time worked. So let's think about the contractor. is usually on a day rate, for example, and there's a task that needs to be performed, and the idea is that you'll come in, we'll engage you, and you will just simply carry out that task. That is different from saying to someone, you're required to come in at 9 o'clock and you're required to finish at 5 o'clock. That's regular hours that they're supposed to carry out. Now, thinking about that, what we can often see is actually if a contractor's coming to do work and that work has to be within an office environment, the office is only open for certain hours. So the whole point is, what's the intent behind that? You know, it could be that that contractor can only walk into that office at 9 o'clock and it has to leave by 5 o'clock. But the point is that person having to do those hours and having to come in and do those hours? And is there, you know, a requirement on them doing that in order to carry that out? So can you see, however, it starts to, you can probably thinking about scenarios yourself and thinking, oh, I know actually someone that they have to do that. I don't really know the reason why, when they've told me what they're doing, that they have to be in at those hours. Next one is manager or supervisor responsible for their workload. Well, obviously that suggests control. If there is someone that's responsible for that workload, control, as we're going to come on to see, is something which would suggest employment status. But on its own, necessarily might not be determinative if we can try and establish why. Sending someone else to do their work. I mean, that's one that obviously substitution is one of those that always has that question mark. And I review employment status for IR35 purposes on a weekly basis. And it's one of those things that is often, you'll see it in the contract, and it'll be a really nicely written contract, and every point of IR35 is very much thought about in that contract, and it says substitution is something that can happen. And then the contractor will fill out an assessment and they will say, no, I've got no right to substitute. And there's a problem there, because the contract is not necessarily reflecting what that reality of that situation is. As we'll see, it's both. It's the contract and it's what that person does on a daily basis. Next one, business deducts tax. Well, if they're going through the payroll, you've got to wonder, is that really someone that's self-employed? Paid holiday. I mean, I would say that that's an absolute indicator that somebody is likely to be employed, because why would an end client be paying for somebody's holiday? But again, who's paying for the holiday? Entitlement to contractual statutory sick pay and maternity or paternity pay. Again, those are things that are available for employees. Next one, joining the business's pension scheme. Well, why would a self-employed contractor be joining the pension scheme of someone they're providing services for? Disciplinary and grievance procedures, those within HR will know that generally those are things that are applicable to employees only. There's only some certain procedures within a handbook that might be applicable to self-employed contractors, but discipline and grievance generally are things that are for employees only. So if you find out that a contractor has been taken through disciplinary procedures, again, there's a question mark there about why. Redundancy procedures, again, obviously, the right to redundancy payment is something an employee has, not someone that's self-employed. I think the next one is a little bit more tricky. So business provides the materials, tools and equipment for their work. That is a more tricky one, because sometimes, depending on the industry, they might be, these tools might be incredibly expensive. So therefore the end client says, well, actually, you can only use our tools because we need to know from a safety point of view that you're using the right tools to carry out the job. So that doesn't necessarily mean just because tools are provided that that person will be seen to be employed. The point is why. Why are the tools being provided by the organisation? Let's get to the bottom of that. Next one, they only work for the business, or if they have another job, it's completely different from their work for the business. I think that's a difficult one, really. In reality, there's very few, from what I've seen, contractors who will be working at the same time for another organisation, because there's, unless they're on a specific contract where their expertise is such that they really are minimally involved in a particular contract and providing information at different points. So again, that can go either way. And the last one, the contract itself refers to employer and employee. Well, that's a problem if you're being presented with a contract that starts to refer to a self-employed person as an employee. I mean, a label is not everything, but it's an unusual thing to see. So the government says if most of these don't apply, you should work out that that person is self-employed. So I think you can probably see that it's not a black and white scenario. We're moving within factors, and each factor is probably moving that arrow one way or the other. So what I'm going to do is I'm going to touch briefly on some case law, which is going to show you what we're why those bullet points are there. Why have we got that kind of guidance? So the ready mixed concrete is the original case for employment law, and if you want to have a read of it, there's the citation for you to find it. But it's not a great read, but what it does do is it gives us some absolute basics when it comes to employment status. So what ready mixed concrete says is there are 3 parts to understanding a contract of service, and a contract of service is an employment contract. So there's 3 key tests that you have to be looking at, and this is what you have to apply, and this is where all those guidance bullet points have come from. So it's a little bit old-fashioned, the language, because it's talking about master and servant, but bear with me, those aren't my terms. So the first one is an agreement exists to provide the servant's own work or skill in the performance of service for the master. So this is personal service. That's where personal services comes from, and you might be very familiar with the concept of personal service. And that's in return of a wage or remuneration in some way. The next one is in the performance of that service, the master has sufficient degree of control over that service. Again, so that's the control test. So we've got personal service test, control test. And the third one are there other provisions, so it's quite wide, that are consistent with a contract of service, and this is other factors. And that's sometimes known as the economic reality test. So it's basically personal service, control, and is there anything else within that relationship which might be suggestive of an employment contract? Anything else? And that's quite wide. Who provides tools, as was touched upon, whether the person hires their own help, do they have to have some admin staff, for example, that can help them, that contractor, they might do, depending on what they do. Degree of financial risk adopted, so that can they make a loss, for example? If it takes them longer to do something, they're not getting paid overtime as someone that's self-employed, they might technically be making a loss. Degree of investment and management of the business, whether the person's paid a fixed wage or salary, absent due to holiday or sickness. These are all other factors which can move that arrow one way or the other. And these factors of personal service, control, and the economic reality test are the irreducible minimum. Those are the minimum things that you need to establish employment status. So if I just touch very briefly on the next case, which is Hall, Inspector of Taxes versus Lorimer. So this is one which looks at other factors, and that's a wide range of factors that might be relevant. So in this one, Mr. Lorimer was a vision mixer. So it's a skilled TV editing role. He was typically retained by approximately 20 different companies on between 120 and 150 separate assignments per year. So this echoes a little bit, I don't know if you've seen the recent Lorraine Kelly decision in the last couple of days, where they were suggesting that she's working for all these different companies, and therefore each separate one was potentially an employment contract in between each one, and that's very difficult to prove. And this, I think, that probably follows this decision, to be honest. And HMR's view that those were separate employment assignments was rejected, and that is what they took into account: short duration of each engagement. So that's why one of the questions we ask when we're looking at someone's employment status is, how long is this arrangement going on for? And sometimes it will just say ongoing. Now that's not really an indicator of self-employed status. If it's just ongoing, isn't that more of an indicator that someone's employed? When you're employed by an organisation, there's no end date unless you're on a fixed term contract. There is not this sort of open end date. The number of separate engagements entered into, I mean, there were a lot in this case, and the same with the Lorraine Kelly decision as well. The degree of independence he had for each particular issue that he was, each particular assignment that he was on, and the expenditure that he had to incur in order to be able to complete those assignments, because this was all about sort of technical equipment that he had to provide. But the court make it really clear, and they do in all these cases, that it's not a mechanical exercise to determine employment status. It's looking at all these different factors and taking an informed decision as to which way that arrow is pointing. So the Young and Woods case is a good one, because often people think that if they label themselves self-employed, that makes them self-employed. And employment status isn't a choice, It's something that happens that depends on the reality of the situation. So in this case, the individual here asked to be treated as self-employed. So he walked in and went, I'd like you to treat me as self-employed, therefore I pay less tax, basically, is what he said. But the reality of the situation was that he was treated absolutely no differently in terms of control on what he was doing on a day-to-day basis as any other employee. So there he wasn't found to be self-employed, despite the fact he wanted to be treated as such. The reality of that situation was very, very different. I mean, he didn't get holiday entitlement or sick pay, and he wasn't subject to the disciplinary procedure in that case either. So those are things that would suggest employment status, but that arrow was pointing much more towards employee because of everything else that he was doing. In every other way, apart from those things, he was being treated as an employee, and that's why it can be difficult to determine employment status. And the final case is the Carmichael case, and this is about the contract. So as I've mentioned, often you'll have a really well drafted contract, and it will already have been reviewed in terms of whether, it's in terms of its IR35 status. You have a lovely contract there. But then the Court of Appeal talked about how a tribunal, so in this case a tribunal, should be able to look outside the terms of that contract to sort of work out what that entire relationship is. And even though there's an actual contract in place, the question is there any other factors which might indicate that some of those things in that contract are not necessarily the intention between the parties? And again, I go back to the point on substitution. I can often see a contract which has been very carefully drafted, which talks about the right of substitution and is very clear on that. But then the reality, which is then when you do an employment assessment test, then looks at the fact that what is that person doing, and the contractor says, well, I'm not actually, I can't substitute. They want just me, they've engaged just me. And I'm like, oh, really? You have the right in the contract, there's a disconnect there. So already, if there is that disconnect, HMRC are going to be thinking, well, what else might not be reflected as the reality of situation that is in that contract?